Can you give us an overview of what the burden would be?
We're supposed to know if the buyer is buying with the intention of using it as residential purchases. Those are very difficult things to determine. Instead of giving us something to look for that is suspicious, we're going to be looking in the broad category of cash transactions among entities or trustees.
It's a lot of information that FinCEN's reporting rules going to require. I think 111 fields of information.
Hi, everyone. It's Mary. This was recorded before the FinCEN implementation date was pushed to March 1st, 2026. Now, the case we discuss in this episode is still ongoing, and the issues are still relevant. Now on with the show.
Welcome to Keys to Real Estate. I'm your host, Mary Schuster. Well, today we're diving into a lawsuit that could reshape how the real estate industry does business. The Treasury's Financial Crimes Enforcement Network, better known as FinCEN, has issued sweeping new reporting requirements that go into effect this December 1st, 2025. For many title and settlement agents, these rules mean collecting and transmitting to the United States government sensitive personal data for a huge number of cash real estate transactions. Joining me are Celia Flowers, a Texas attorney and title agent who stepped forward as the plaintiff, challenging the validity of the new requirements. Also with us today is Luke Wake, an attorney with Pacific Legal Foundation. Together, they're challenging the legality, the constitutionality, and the sheer practicality of these results. So we'll talk about what's really at stake, not just for agents, but for small businesses, attorneys, realtors, property owners, and regarding privacy rights across the country. So please enjoy a terrific conversation with Celia Flowers and Luke Wake. The presenting sponsor for this season of Keys to Real Estate is Closing Lock. Working in title, do you ever feel like you've got a target on your back? Every year, $2 trillion moves in and out of escrow accounts in the United States. Fraudsters are watching and waiting for one wrong click, one unsecured email, just one oversight. And then just like that, your client's life savings are gone. That's where Closing Lock comes in. Closing Lock provides title companies a secure, all-in-one platform to prevent fraud, protect funds, and streamline closings. Over 1 million home sales have closed safely without incident in Closing Lock. The fraudsters only have to be right once. Title companies have to be right every time. Closing Lock has your back. Visit closinglock.com today to learn more. Welcome to Keys to Real Estate. We're so glad to have you here, and you're doing such important work. Celia, if I could, I'd like to start with you. So you're an attorney and a title agent in Texas. When did you first hear about the new FinCEN reporting requirements, and what was your initial reaction?
Well, as you know, we were doing 6-county reporting in a very narrative way. It's probably in spring of 2025, we started hearing about it through our associations. And of course, what did I think? It was a huge new burden to add to agents, especially independent agents across the state. Very hard for them to get the information they need and set up their processes and procedures. And so it would immediately hit me as, you got to be kidding me.
Fair enough. Most of our audience knows about the reporting requirements that are coming up that are scheduled to go into effect December 1st. We've done a lot to try to educate folks through our publications and this podcast and our blog and a lot of things. Can you give us a 2-minute overview of what the burden would be for reporting for your title settlement agent and other entities?
Well, we're going to be looking at all cash transactions of real property for residential purposes. And we're supposed to know if the buyer is buying them with the idea of using it or intention of using it as residential purchases. So those are very difficult things to determine to start out with. But then you have to look at everything about the seller, everything about the buyer, who are entities. Entities are trusts. And a lot of that information is not recorded down at our county clerk's office. So obviously you've got to collect things. I wrote down a little bit besides just your legal name and your trade name, your address. You have to provide IRS numbers, Social Security numbers if that's appropriate. And of course, we've never collected Social Security numbers on buyers, only the sellers. Date of birth, don't ask me my date of birth anymore. And I'm pretty sure that the folks that are sitting across the desk from us are not interested in that, and I'm not sure what that really matters. But a lot of non-public personal information is going to be compiled. And things that, besides the tax numbers, you're going to have the street address. That sounds like no big deal, but it is hard times to get the street address sometimes instead of the property description or both. And so you have to have all the information about their citizenship, if they're citizens or not citizens, and you don't always know that. There's just no way we can know all these things going in. And instead of giving us something to look for that is suspicious, we're going to be looking in the broad category of cash transactions among entities or trustees for residential purposes. Luke, what have I missed on that? Did I miss anything on
Yeah,
that?
no, I think it's a good overview. It's a lot of information that FinCEN's reporting rules going to require. I think 111 fields of information they're going to require these businesses to collect, and they first have to decipher whether or not they actually have to file a report. Like 8 exceptions. They're very narrow exceptions. Any sort of residential, non-finance transfer of residential property has to be presumptively file a report on. But you have to figure out whether one of the exceptions applies. For example, if a transfer is happening pursuant to a divorce or because of a death, you don't have to file a report then. But again, you've got to fill out all of these 111 fields, and including very sensitive information about, say, beneficiaries of trusts, including, say, minor children. And again, these are commonplace transactions that these folks do on a daily basis, and there's major penalties if you begin to get things wrong.
Yeah, this is the Bank Secrecy Act that we're talking about here. And it sounds like it's assuming some suspicious activity where oftentimes there is not. And I mean, Celia, in your market, for example, is a cash transaction inherently suspicious in your world?
Absolutely not. First of all, I want to dispel the fact that people are coming in with bags and bags and bags of cash and putting them on your desk. I mean, across the state of Texas, most agents only allow $1,500 in cash to come to your desk. And cash transactions themselves are not suspicious. We have folks moving in from New York and California who have sold very high-end houses and can easily pay cash in this market. And so, no, it's not at all. Things for children, to set up for children, and all kinds of reasons that you would do it for business purposes, for tax purposes, estate planning purposes. So that is just not uncommon. But we're not getting anything other than $1,500 in cash. Everything else is coming through some financial institution, either in a wire or in a cashier's check. So it sounds like it's cash, it's bad. And that's just not at all what's going on.
Like stacks of bills. Yeah, right.
We don't get that.
Yeah. Well, so let's talk about the effect that the requirements would have on your business if they go into effect either December 1st or some other time.
We're going to have to do all new training. We've started this already, of course, way in advance, but it's certainly not something that we're used to. And so thinking through the process of this, because we are big process people, big process map people, and it sounds like, oh, well, you just get this information and put it in this 111 fields and go on. But how many times are we going to have to call those individuals to get that information? How many times are we going to have to email them? When we started working on our process map, it was very hard to put one right after the other because you don't know when. It's kind of like closings. You don't know when you're going to get the call back from somebody with the information that you need. So, and you're talking about sort of 2 different parts of your whole business too. Our closers are very good at filling out a HUD or a closing statement and having the counts balanced. But they don't understand all of this other, and they don't understand the purpose of it. And it's really hard for people to clue in and do it correctly if they don't really have a full understanding of its meaning. What they see is somebody coming to their table and they're asking a whole lot of personal information, a whole lot of personal questions too. The folks at the table don't know why. And so they are going to be feeling like you're asking them a lot of personal questions. And honestly, will refuse to answer many of those questions. So
well, sure, because a lot of times those entities were created to keep that stuff kind of private and layered for reasons that are valid.
And we never see a trust agreement. We have a different form in Texas that allows the trust attorney to fill it out to give us the things that we need, who can sign, but not all this detailed information about the beneficiaries. And as you said, the beneficiaries may be children, and maybe somebody special out there that doesn't want to know everybody in the world to know where they live.
Yeah, exactly. Well, and in case of all this, with people getting doxxed, there's just so many things coming together here that add to the complication, I think, of this thing going live that think it's really good to sort out, talk about, and try to make some folks in charge of things aware of. Quickly, I know your case doesn't specifically focus on the costs of compliance, but I wonder, as you started doing some of your process mapping and all that, did you estimate your additional cost either per file or annually or anything like that? Do you have an idea what that would run?
Well, the problem I'm having with that is that I don't
Mhm.
really have a true time or a true thought about what time it's going to really take to get all that information for folks.
Yeah.
Then the other thing I'm struggling with is what it's going to be adding to our expense to keep that information. We've got non-public private information that we're required to keep confidential, even in the business we're in right now. But now we're going to be transmitting that information. We're going to be keeping more of that in our files than we ever have. Most of the time we've been able to purge the files on the loan. I say alone because it comes up, but any information that's personal, we're able to purge and shred before we keep our files going forward. All those things, I'm just not clear what that cost is going to be yet.
I understand. I hope that when people are beginning their rough calculations of what this would add, that they remember that the cost of their cyber insurance policy is going to go up because they're holding oodles of more, not only just data and not only just transaction data, but NPI data that has to be secured in a very specific way. And as cyber insurance coverages are going down and policies are going up, I think that's a big factor. You said an important word too that I wanted to touch on. How are you supposed to transmit that sensitive NPI of others to the government? How are you supposed to do that?
I think that's something we don't know yet. There's supposed to be a
Okay.
portal that we transmit into, but I don't understand yet how it comes out of my system securely into their system securely. I just don't know. I don't have
That
it
securely is a big part. Like you
securely.
can do a web upload of a GIF or anything, but it's the opposite of secure. So I haven't heard any answers on that, let alone good answers that I would feel good about transmitting people NPI over. But okay, we'll save that for another day. So what made you, all things considered, looking at all this, what made you decide I can't just sit around and wait for someone else to solve this problem? I need to get in there with the assistance of PLF, of course, and support and fight this. It'd be easy to just sit and shake your fist at the sky and be mad about it. What made you decide to get in the arena?
Well, so Mary, I think you know me well enough to know I'm a squeaky wheel. And so I was asking and asking at Texas Untitled, what are we going to do? What are we going to do? How can we do it? What are we going to do? And of course, an association has very little that they can jump out there on. They've got too many members, too many people they're representing. And my daughter and I are just a title company owned by my daughter and I. And I was very, very pleased that Pacific Legal Foundation agreed to take this on because they can represent those people who couldn't represent themselves in something like this. So I guess I just appreciate them for stepping in and taking this over and organizing it. Certainly not my area of the law, and they've done a great job in that.
Well, I'm going to pivot over to Luke then for a little bit because PLF does take on some great causes. This is one of them. Luke, for people that aren't as familiar with this specific case as much, what are sort of your core legal arguments in the case?
Well, we raise a few core legal arguments. First, we're arguing that this is a separation of powers problem for two reasons. One, because these federal agencies, they can't just go out and make rules. They are creatures of law. They only have power, legitimate power, that is, to do things that Congress has actually authorized them to do in the statute. And so firstly, we're arguing that FinCEN really doesn't have the authority they're claiming. They're claiming very sweeping authority that would effectively allow the Secretary of Treasury or FinCEN, who has sub-delegated authority from the Secretary, to require disclosures on essentially any kind of consumer transaction. Of course, right now they're focused on persons involved in real estate closings and settlements. Those folks like that are expressly listed under the Bank Secrecy Act as financial institutions that are subject to regulation from the Secretary of Treasury. But in addition to enumerating, I think, a list of 26 different types of businesses that are financial institutions and subject to whatever reporting rules that the Secretary makes rules on, there's also an addition that says, and the Secretary of Treasury and FinCEN, by subdelegation, can add to that list and deem any business a financial institution that has to comply with its regulations. And so, again, we think we see a sort of a bigger issue here. So there's the statutory argument that they just cannot, under their claim of authority, they say that they do have authority to require reports on suspicious transactions. But that does not mean, we don't believe, that they can require sort of categorically on a systematic basis reporting of every non-finance residential transaction in America, because these are commonplace transactions that Celia was noting. They happen all the time. There's plenty of legitimate reasons why someone would want to maintain privacy, certainly for a minor, but you could also think about victims of domestic abuse or whatever. But it is just these people incorporate all the time as a means of just doing business to minimize liability for tax planning reasons. People put properties in estates all the time for tax planning, very legitimate reasons, right? And so to just assume that these are inherently, just to deem them sort of categorically as suspicious and say that that's the trigger for their authority, we think is wrong. So that's the first argument. And the second argument is that if we're going to construe the Secretary of Treasury's authority as being so open-ended that the Secretary could just deem any transaction suspicious just because he thinks that systematic reporting might be in some way helpful to law enforcement, then there really are no limits on the Secretary's authority to require disclosure of any kind of consumer transaction. Because again, remember, it's not, they could, when it comes to any financial institution, if they can deem any transaction suspicious because it might be helpful to law enforcement, then what is the limit? Because the government's always going to say that more information is going to be helpful for law enforcement. The Eye of Sauron just wants to see more. So we have sort of a constitutional argument here that says Congress cannot give a blank check of power. Because why? Because the Constitution says Congress writes the laws in our country. You can't give away that power to make law to an unelected Secretary of Treasury or FinCEN. In addition, we're arguing that there's a violation of the Commerce Clause. So the federal government has no business really regulating this at all. When we're talking about purely intrastate transactions in real estate, that's an issue that's traditionally been regulated at the state and local levels. It makes no sense, especially if people are using, in some cases, like an in-state bank to transfer their funds. Nothing is happening across state lines. So Congress really has no business regulating and these reports. And by the way, they're not regulating anything. The transaction itself is regulated at the state level. They're merely requiring the reporting of a transaction that is lawful under state law. So we think that succeeds even under very expansive authority that has broadly upheld the power of the federal government to do all sorts of things that I think James Madison and Thomas Jefferson would have made their heads explode. Notwithstanding that, this goes beyond the outer limits of anything that I think the Supreme Court has ever upheld. And then additionally, we argue that there are serious Fourth Amendment problems here. And because the government is doing all of this requiring this reporting, it says, to help law enforcement identify people who are involved in criminal activity. Well, first of all, we don't think you can categorically, again, presume that everyone involved in residential transactions is somehow nefarious. But if the law enforcement is trying to get these records to build a case against someone, they need probable cause and they need to go get a warrant. There's a right way to do this under the Constitution, and they're doing it the wrong way. So,
well, and interesting, Celia, I imagine you're feeling and would be compelled to collect, transmit, maintain for however long, your underwriter's record storage requirements, the states, your company's policy, whatever. So that it all gets very kludgy. You're being compelled, they're being compelled, and the stance seems to be suspicious until proven not suspicious.
Exactly. Guilty until proved innocent.
Sounds like the country I was raised in. Not. Luke, did you have any qualms about bringing the case, or was it just pretty obvious on its face that it needed somebody to champion it?
Well, something smelled rotten to me. Something that was rotten in the state of Denmark is I think they said Hamlet, right? So when I see something, it seems a mess. The government is doing something that I just have a sense that they really shouldn't be doing. I take a close look at it. I'm leading this project within Pacific Legal Foundation's Separation of Powers program, where we are trying to breathe life into these doctrines of separation of powers that really have languished since really the New Deal era. We're trying to breathe life into these doctrines because ultimately enforcing separation of powers inures to all of our benefits. The Constitution is not about just sort of old men in wigs and old ideas. It's about real life, and government when it overreaches, it crushes people. And we can give you not just the Celia story, but many other stories of people who are caught under the grind of the administrative state. And so we're working very aggressively and trying to find the best cases to move the needle. And always thinking at Pacific Legal Foundation about the sort of issues that are most salient that may ultimately work their way up to the Supreme Court and actually help set good precedent to push back against what I often call the rise and rise of this constant march of the administrative state. So when I look at a case, that's sort of, because we're doing these things pro bono. We're not charging our clients a dime. That enables us to bring cases, as Celia noted, that wouldn't otherwise be brought. But it's very important that we're good stewards of the resources that our donors have given us, and being very strategic. And so that's sort of the main thing is like, how good of a vehicle is this to get at the constitutional issues that we think are really important right
Well, let's talk about that vehicle a little bit. I'm wondering if I'm representing the government and I'm going to be on the opposite side of this case from you, what's my steelman argument? What's my best go?
Well, they are, as alluded to a few times here, trying to paint this narrative that there's really something nefarious going on with these transactions, and that they admit that the vast majority of them are legitimate. If you back up for a second, recall that they had for a while issued these geographic targeting orders that required in certain municipalities, certain counties, reporting certain non-finance transactions. There was always a higher dollar threshold. Now they've eliminated the dollar threshold entirely, so everything is suspicious, right? But they say, well, in 40% of the reports that were filed, the people involved in those transactions when we were doing those geographic targeting orders, in 40% of those cases, we found that someone involved in that transaction had been flagged by some other financial institution for doing, some sort of suspicious transaction. Well, that certainly tells us nothing at all, because it might just speak to the fact that banks and financial institutions are erring on the side of caution and over-reporting all the time. You and I might be flagged on pulling money out of the ATM. We just don't know, right? So they're painting this narrative, and the whole idea is sort of just trust us. It's reasonable that we know that there's cartels and there's bad people out there. There's Russian oligarchs, and they're trying to do things, and this is going to help us do a good thing. And sort of our answer to that is, if it's really such a good thing, well, one, it shouldn't be an elected Secretary of Treasury deciding for the entire country that this should be done. It really should be, those sort of debates should happen in the halls of Congress, if they're going to happen at the federal level at all, which again, we argue they shouldn't. The federal government has no business here in the first place. So, but I say that because that is kind of principal to key to their statutory argument, is they're saying, well, these are suspicious. And I think they think that if they can just succeed in sort of painting this narrative that these transactions are suspicious, courts will be sort of deferential. Courts historically have been deferential to the agencies and promulgating regulations, but I think the pendulum has swung in recent years. And on that, we can certainly talk more about sort of deference to agencies if you want later, but that was a major problem for years and years.
Yeah, well, I'm interested about that statistic, that 40% statistic that they've popped somewhere else on a suspicious warning, perhaps at a financial institution. There might be an association. It doesn't necessarily sound like correlation or causation anywhere in there, but I assume that people who have a lot of cash do a lot of things in cash, so 10 grand to the bank, suspicious activity report, right? Or 10 grand to a title company. So I could see how the same person could be double, triple, quadruple hit just because they do a lot of stuff with cash. Am I right on that scenario, or no? Am I all wet?
Yeah. And bear in mind that the FinCEN also just recently did a order requiring banks, financial institutions to report withdrawals from ATMs of over $200. And that, of course, made the news, and there was an injunction against that as well. I think that goes again to the idea that they think that there really are sort of no limits, sort of cabining and controlling their authority to deem any kind of transaction suspicious if they just think it is, as one man thinks it is. So actually the bigger issue here is they're not suspicious, not inherently suspicious. We think we're right about the statutory argument. But the bigger issue is if you buy into that narrative, if the court wants to entertain that, say, okay, well, the statute says that the Secretary of Treasury and FinCEN can require reports on suspicious transaction, and that means that FinCEN gets to decide categorically that certain entire classes of transactions are suspicious just because there are some bad actors out there, or because it might help law enforcement in the aggregate to have systematic transactions, find sort of unlawful violations of regulation. Well, guess what? You can't move a stone in the United States of America without violating potentially some sort of regulation. I mean, everything is regulated. So systematic reporting requirements on any kind of business activity is going to yield information the government finds useful. And if that's the case, then there really is no limit on the Secretary's authority. And so that gets to the bigger problem here. It's like, okay, if we accept their view of the statute, the bigger problem is that Congress has given a blank check. And of course, by the way, their argument on that is, well, the Supreme Court hasn't struck anything down violating this non-delegation doctrine, the idea that Congress can't give away its power to make law, since 1935, when the Supreme Court infamously struck down provisions of this National Industrial Recovery Act, which Congress passed us during the New Deal and in response to the Great Depression. It was certainly an economic emergency, but they basically said, we don't know what to do. The President of the United States, you can write whatever codes of industry you like that you think might in some way be helpful. And the court struck that down. Well, we think this is the same thing.
Yeah, it feels that way. And I did want to come back and talk about the post-Chevron world. Our audience, both in our publications and here, are very up to speed on Loper Bright and Postek. We were at SCOTUS for the oral arguments on Loper Bright, and we've been trying to explain for the benefit of our attorney audience and our non-attorney audience what being in a post-Chevron world would really mean for questions like this. It's been hard to talk about theoretical. We might be here. Is it different now in a post-Chevron world, your likelihood of prevailing?
It's more concrete when you're dealing with real cases, and that's why judges don't decide abstract questions, right? But no, there was no doubt that overturning the Chevron decision, which ushered in this 40-year experiment with letting agencies decide the scope of their own powers, which was just crazy. Getting rid of that was a very good thing because it leveled the playing field. Now, what does that mean in practice? Well, I think there's still probably a tendency on the part of a lot of judges just sort of reflexively to err on the side of deferring, even if they're not explicitly saying that. But they can't do so under the Chevron doctrine, which required deference in the past. Now the courts have to decide on the best interpretation of the statute. And again, that levels the playing field. It means that if a judge looks at the arguments, and by the way, judges have all sorts of tools in their toolbox to figure out the best meaning of a statute. That's what they do. And so we go through that toolbox and apply all the tools. And they're just sort of logical presumptions. Like Congress has been very specific over here about something, and then there's a general statement over here that allows an agency to do something generally. Well, the more specific thing, obviously, Congress intended that to limit the more general. And there, a bunch of things like that. How that will play out here, well, again, if this was litigated in the Chevron era, when courts just had to defer to an agency's interpretation that was arguably reasonable, as long as it was any sort of ambiguity, well, it would be a more uphill battle on the statutory front. But today, I think we have very compelling arguments on the statutory front. But we set that aside. I think we've got some exciting arguments on the constitutional front that and they work in conjunction. By the way, the constitutional argument reinforces the statutory argument because courts, generally speaking, I think appropriately so, because we all should be mindful. We have to assume Congress is mindful of the Constitution. We shouldn't interpret this statute as giving the Secretary of Treasury a blank check to require reporting on any transaction they want, because that would be unconstitutional. That's all the more reason to embrace sort of a reasonable narrowing construction that prohibits FinCEN from doing all this. And by the way, can I just circle back on one other point?
Please, yes.
This whole narrative that they want to paint that there's all this nefarious business and there's some sort of gaping hole out there because they haven't previously required reporting like this of non-finance transactions. It's malarkey, frankly, because as Celia noted, when someone is involved in one of these transactions, they're not showing up like Walter White with duffel bags full of cash. The money is coming from another financial institution that has an obligation under the existing framework to report suspicious transactions. So it's not like this is unregulated. The transfers for these properties, I mean, it may be a different matter if it's coming from some sort of offshore account or something like that. But if that's the concern, then they should have written a different regulation.
Yeah, agreed. Well, see, I'm wondering, when this first came on your radar screen, you're an attorney, mostly doing title, real estate, oil and gas related stuff. So maybe not living over here in constitutional land. Did you recognize it right away as sort of a potential or apparent glaringly obvious constitutional violation question? Or did you really just come at it pragmatically from the business operations side of it?
I did. I came at it from the business side of it, and from other agents' side of it. We have a lot of independent agents in Texas, and a lot of them haven't gotten this information as clearly as they should have, either from our national association or from our Texas association. They try, but members are not always included, everybody across the state. So no, I just came at it from the business perspective and what it was going to do to the little guys to have to comply with something that didn't seem to have a purpose.
Right. And I think as far as industry goes, they tend to be very focused, understandably right now, on the operational, the what when, how, why to do it right, and let's get it implemented, update our workflows, all of that. And that's why I thought this conversation was such an important one to have, because those constitutional questions kind of get set aside when you think, all right, this thing's going live 12/1, we got to comply, we got to be within it. It's like, well, wait a minute, hold up. Should the government be asking for this? Can they require it? Can you be compelled to do all these things? And can I be compelled as, a seller with a trust to give you these documents that you aren't entitled to get the closing done, especially in Texas, where you said there's an alternate statement they can make so you don't have to even look at the trust, right?
The non-public private information that we're gathering really did concern me as well. It's, we've done nothing but try to redact information out of the public record. That's been the focus for years. No more filing with Social Security numbers on it. All of that has been the focus, and suddenly we're collecting that information from our folks that are looking to us because they're our clients, and they're coming in to close a specific transaction, and suddenly we're asking them information that in our minds and in their minds have nothing to do with that transaction. We just seem to be wanting to know gossip on them. And you laugh, but that's how it's going to feel to people. I mean, it's going to feel like, it's none of your business.
And have you thought about, if this goes into effect 12/1 or later, have you thought about, like, are you going to give the script, the staff scripts as to when somebody says, what do you need this for? You're not entitled to this. You don't represent me. What the heck? I assume you're going to have to get right down to the script level. And here's the way to speak to my manager. Like, this could get pretty dicey at the table and right before.
That's right, because whatever script I give my people to say, this is the law now that we have to do that, they're going to say things like, well, who made that law? When did they make it? And so pretty soon it's not going to be just that closer at the table. It's going to be anybody from the law office they can have people call. There are going to be more lawyers probably involved. Although I will say the attorneys aren't understanding this at all and understand that it applies to them if they do any of these functions. And so it's going to be a big mess.
Well, and there's going to be sellers, I would think more predominantly sellers, but buyers also that'll just walk. They'll just walk.
The timing of it is sometimes very crucial to sellers. They're about to be foreclosed on, or they're in a 1031 exchange situation. They're trying to identify other property, and there's deadlines for that. And I just think this is going to slow the closings down. I keep waiting for the real estate professionals to come in and say, what? That's going to slow that closing down. And it is going to slow.
Well, right. And I wanted to ask you both what your thoughts were about, the marketplace's preparation. Not only, again, the entitlement settlement companies going, okay, we have to ask this, we have to get this, we have to get this, and transmit it somehow and store it forever or some time period as yet undisclosed somehow. But I wonder, do you feel like the real estate attorneys and working out from there, lenders and realtors, have any idea what's the freight train that's coming their way?
Well, I know the realtors don't. And I know the lawyers don't, because there's not been anything mentioned at the state bar level in the real estate section yet. And they don't, and they wouldn't know what some of these words even mean to comply, because they're on the cascade list. Like, they don't know who above them reported or didn't report, or did it fall to them, or do they have to call them and find out who actually did the report? They have to get a copy of that report in their file so they can say that I'm on the cascade, but somebody did it. Nobody knows. Nobody knows.
This is what I often refer to. I come from a trade association background, and I was working with small businesses for years at NFIB, and talked to so many small business owners about these sort of the regulatory landscape is constantly changing. And this is what I would often call a regulatory landmine, because people just, if you don't know, if you're not ahead of the curve on this, you're going to step on it, and it's going to be very problematic. And of course, there's criminal liability if you're intentionally ignoring the rules. But there's also very significant liability if you're just making mistakes. And unfortunately, this is going to be very complex and very tedious. I think you asked earlier how much time and energy was going to be involved. FinCEN estimates, I think, very, very inappropriately, very conservative numbers on that. I think they said it's going to take on average 2 hours to collect the information per transaction, and then 30 minutes to actually file the reports, which I think is just ludicrously conservative. But even if you accept that, in the aggregate, that is adding a lot of time and extra expenses to these transactions. Either the companies have to eat or consumers have to eat, and that's all a problem. So it's rubber hits the road here when there are practical, real life problems for our lives and our livelihoods when the government is acting outside its lane and exceeding its authority, and that's why it's really critical that we hold them to account in cases like this.
Agreed. I mean, as granular of a question remains in my mind, and maybe I've been asleep and you have new information for me, but I'm not even sure at what interval, if I'm a settlement agent, I'm supposed to report, because I think they talked about a 30-day, but is that a rolling 30? Is that a calendar 30? So all my closings from the 31st have to like, is it months in a like, has that been straightened out?
It's regulations for sure. My recollection is it's 30 days, but there's some sort of caveat to that. So it's sort of thing that you want to cross your T's and dot your I's on as we get close to the implementation date, if it goes into effect. And again, I think the hope is that it doesn't go into effect. There's a couple lawsuits on that, not just ours, but we're hoping to vacate the rule. If we win on the merits and we file summary judgment motions, if we succeed, if the court vacates the rule, our view is that that's universal vacatur, and that which is basically a fancy way for saying it's striking down the regulation, so it doesn't apply to anyone. But in any event, we will see how this unfolds.
Yeah, I agree with you. It's not, and I think that's important for people to understand, is it is not an annual reporting requirement a la for sellers. This is the shortest increment we're going to see, I think, is 30 days. And so it's not a once a year push. It's going to be consistent. Well, Celia, I have to ask you, I know that, when Dodd-Frank came around, you were one of the small businesses on the Small Business Advisory Group and helped tailor some of those implementations that way with small business thoughts. So you've been leading this charge for us for a while now. We thank you. But Celia, I'd like to ask you, what do you want others to know about why you're doing this, and just why it's important to you? And then after that, Luke, I'd like for you, if you could just sort of sum up for our audience listening beyond the particulars and when do I report and who do I report and where in the cascade do I fall? Could you just talk about, what this case would mean for small business owners, whether you win or lose? So Celia, go ahead.
Well, I mean, it is, as I said, it's important to me to take care of all of our agents in the title industry that we can, and keep them informed and keep them up to speed and make sure they do things right. This is a very burdensome, time consuming thing that they're going to have to work into their schedule, because as you just said, it's not going to be 1099s once a year. It's however many closings you had that month, or the argument is that month, or they're due the month after. It's however many closings you have. You can't even predict that. So I just want our agents to be able to be in the best position they can going forward. And I believe that the government already gets the information that they need. That's my own belief. And then if they don't get the information, tell me to report an overseas wire, tell me to report something like that, or put a dollar amount that you cannot do any other cash other than this dollar amount, something that is reasonable for the normal person. All title agents aren't lawyers and don't have to be and shouldn't have to be. So it's just trying to get it down to a level that everybody can understand.
Luke, what should folks be thinking about in terms of what something like this means for them, whether you prevail or do not prevail?
Well, certainly, unquestionably, the case has implications for the title insurance industry and people involved in real estate closings and settlements. But we think that this is about something bigger than that, and that it's about something that, frankly, anyone who is running a small business out there really should care about, or whatever they're trying to do. Because we're talking about the sort of constitutional framework. If we value having a limited government, if we value the idea that the government should answer to we the people, which it should, otherwise we have an autocracy. If we value that, then we really have to bring in the reins on agencies acting beyond their authority, or agencies asserting, which they very often do, that their authority is essentially limitless and that they can do what they like. That's a real problem. And we've got to rein that in. There's some other big issues here as well, like their assertions that they can require businesses to require reporting on consumer transactions without, for criminal purposes, but without getting a warrant, that's a very significant issue as well. That, if we set precedent on that's going to, I think, inure to the benefit of businesses across industry lines. But I think we should all be hoping that we can rein in FinCEN on this issue and set some good precedent on the way.
Right. Yes, you couldn't have said it any better than that. So you clarified it so well. Thank you. I just wondered if Celia's going to have her closers read buyers their Miranda rights before they start closing. I don't know. Luke, back to you. Just for a logistical question, what do you anticipate the timeline to be on your case?
We, as I noted, we are fully briefed on this motions for summary judgment. So we're hoping, and I'm really expecting, that we should get a decision before. I mean, I guess you can never know with a crystal ball, right? But the hope is that we get a decision on the merits, meaning the court actually just decides,
Yes.
Are we correct on the law or not, by before this is supposed to go, before the implementation date, which is effective December 1st. So we're hoping before then we get a decision. And I realize the sooner the better, because people are trying to figure out, well, what do we got to do to gear up for this thing? But that is the hope. Whether we win or lose, though, I'm sure the government or us, one of us, will be on appeal to the Fifth Circuit Federal Court of Appeal from there, and we'll continue the fight all the way to the Supreme Court if we have to. But meanwhile, as I noted, there's some other lawsuits out there. One of which is, I believe, the Fidelity lawsuit in Jacksonville, Florida, and they have, I believe, a hearing next week asking
on September 3rd
to issue a preliminary injunction, which would be, I think, a good thing. However, recent Supreme Court decisions have sort of limited the impact of a preliminary injunction, really just to the parties involved in that case. So it would be, I think, what we ultimately need here is a win on the merits.
Yes.
In order to get sort of the sweeping relief that we think is appropriate, that is to strike down the regulation.
Yes. Well, we'll certainly keep following it and we'll keep everyone informed. I do want to specifically thank you both for the work you're doing on this. But before we sign off, Luke, I know you're working on some other cases right now that our audience might be interested in. Can I get you to talk about those for 2 minutes?
Yes, I'm happy to talk about my other cases. Is there one in particular you're interested in, or just
the Swamp Buster stuff, maybe some Clean Water Act stuff? I don't know. What do you think people might want to know about?
I've got a really interesting Clean Water Act case that we're dealing with in Alaska at the moment. Of course, PLF, Pacific Legal Foundation, has for years sort of, I think, been the vanguard on pushing back against just overly aggressive assertions from Army Corps of Engineers and EPA, sort of always try to stretch the scope of their authority. They see a puddle and they want to call it the water of the United States. And the true story, we had to go to the Supreme Court twice on behalf of the Sackett family a few years ago. My friend and colleague Damian Schiff argued this case, the Sackett versus EPA. This could have been your mom and pop or your uncle and your aunt. I mean, they were ordinary people trying to build their dream home in Priest Lake, Idaho, and they went to lay the foundation. I mean, there's development all around, right? Right. And they lay the foundation, and EPA shows up and says that's a wetland, and you've got to remove all of that gravel, and spend thousands and thousands of dollars to remediate this environmental damage, bring it back to its native state. And they said, well, we don't think it is. We want to contest their jurisdiction. They had to fight all the way to the Supreme Court and we won this, but just to get an opportunity to contest EPA's assertion. Meanwhile, facing, I think, $5,000 per day in fines. That's wild. So that's an example of the sort of stuff we've done, but one that's presently happening in Alaska. So there are standards in law for when someone should be able to get a permit under the Clean Water Act to dredge or fill is needed sometimes for projects. And there's actual law on this. And yet there is a provision in the Clean Water Act that says that the EPA administrator has authority if he wants. He doesn't have to do this. There's nothing like guiding or channeling his discretion. He can, if he wants, issue a veto to essentially override those legal standards whenever he decides that a permit would be undesirable, which is or inappropriate, I think, is the text of the statute. But the statute doesn't define that. It's entirely to the EPA administrator to decide what is or is not unacceptable in his sole discretion. And we think that that's a very good example of Congress writing a blank check. And so we're challenging a similar sort of theory in that case and several others that we're working on in the federal courts of appeal, and sort of trying to breathe life into these separation of powers doctrines. And of course, for people involved in real estate development or whatever, everyone very concerned about the reach of the Clean Water Act. This is project in particular we're dealing with in Alaska, we're representing native corporations that are relying, they're trying to help facilitate the development of these mines that would bring much needed minerals for all sorts of important purposes, and it would bring vitality to their community. I mean, these were dying communities, and they're losing like on the order of billions of dollars because the EPA has decided that they're going to veto and not allow any permit for these mines, regardless of whether or not there's any environmental impact here, which is...
It is wild. Well, there's just so much going on right now. There's so much at stake. I mean, we have this huge and looming housing affordability crisis that many of these things, in addition to being constitutional questions, really negatively impact that. You're right. We've got private property rights. We've got privacy rights. We've got separation of power considerations. So it's like this whole gumbo of issues here that you guys are helping get some sanity put to the questions, some answers of sanity, I guess, hopefully, for those questions. So thank you both so much for taking this on. I know that the industry is going to be cheering for your success. We'll be following it closely. We'd love for you to come back when it's all said and done and tell us how it all worked out and give us that inside out view. We'd really appreciate it. But in the meantime, just thanks for going into battle.
Happy to be doing it. Thank you to Celia for standing up, taking a stand.
What a great conversation. Thank you both, Luke and Celia, so much for joining us today. Folks, obviously this case is about much more than compliance. It's also about the future of privacy, business operations, business obligations, and the limits of federal authority. So as the December implementation date approaches, we'll continue to track this lawsuit as well as the other lawsuits closely, and we'll cover them in our publications, on this podcast, and in our blog. Also, there are ways to reach out to Luke, Celia, or Pacific Legal Foundation in general that are included in today's show notes, should you need to talk to them about this case some more. So for now, keep asking the hard questions, keep preparing, and keep your eyes open. I'm Mary Schuster. For October Research, we'll keep bringing you the information you need to keep your business strong, because we know that knowledge is the competitive advantage.